to be paid. That has not been paid. Third, again, my lord, the term loan that is to lordship.
My
Question
impression is that he
lordship,
has failed to make any payment.
Why did you mislead this court?
exactly.
Well, it was on the instruction of the petitioner, my lord.
I'm not saying you.
Yes.
Why did your client mislead this court?
It was under the impression that he will do that, my lord.
Then you are vacating this interim order.
My lord, lordship
My
may
lord,
pass appropriate order.
issue is not interim order, my lord. What I'm submitting, my lord. No doubt, lordship. Definitely, they failed to suppose comply. Therefore, they are not entitled to get interim. Question is that, my lord, kindly see the practice which has been adopted in this, my lord, writ petition by affidavit. It has been stated that they are willing to pay the amount. So therefore, on relying on that version, lordship, definitely, my lord, give them suppose, my lord, that protection. Now, once they get the protection, my lord, what we have, my lord, suffered that because we have obtained a district magistrate permission on that day, and we have also deposited 50,000 by way of challan. Now, earlier, my lord, because of their interference, the district magistrate not acted upon. Therefore, we approach before this honorable court by way of writ. Then this writ court has directed to deputy district magistrate to comply with the direction, my lord. Now, lordship, I pray that a cost may be imposed for them against them, so that nobody should take this kind of recourse in future. Number one, and number two, lordship, my second prayer is that so far the respondent of is concerned, district magistrate, well, he may be directed to, my lord, do the needful, my lord, within a week, my lord.
No, regarding
Or
the direction, I have not any submissions to make. But in this writ, lordship will definitely, lordship may pass appropriate order. But in my respectful, in my writ petition, my lord, a direction against me may not be passed. Whatever they may, district magistrate may do, may take its own course, my lord. That is my respectful submission.
I say, purely a case of misleading to the honorable court, my lord.
Otherwise, my lord, the petitioner.
So why can't you pay? Why didn't you pay?
My lord, he tried, my lord, the person. In fact, he had tried to sell out his existing business in a partner, and his trying to infuse some partners. But the amount is so high that in short time, the persons are not being able to transfer the amount. On the commitment, they issued the check that I'll transfer the amount. On that commitment, he issued the check also as per the direction. But that the person kept the payment on hold. That no, we'll need some further time to discuss the matter.
These are contradictory story, my lord. Nothing is there. What document he has produced that the check has been paid? My lord, this kind of story, no, anyone can create it, my lord. Question is that you have made a specific submission that within time frame, you will pay the amount based on that, my lord, interim order was given. Question is, my lord, that is not a issue, is that you have made a wrong statement. You know it well that you don't have any money in your pocket. But despite of you made a statement before this honorable court and obtained that, my lord, protection. But this kind of practice has to be, my lord, taken care of, my lord, very seriously. And my lord, why district magistrate now required? Because he failed to satisfy this honorable court, the basic principle. Now he has to hand over this property, my lord, by his own volition, my lord, within this week, my lord, because of this kind of, my lord, treatment that has been given to this honorable court. He has to hand it over, my lord. The direction may be passed by this honorable court. The petitioner himself has to hand over the property to the bank, my lord, within this week, without any interference. My lord, district magistrate required because they are creating a law and order situation. That's why that protection we have sought for. There is a case that you have defaulted before this honorable court by making some wrong submission and obtain a protection, my lord. Because only that cause, my lord, now a direction may be passed by this honorable court to them to hand over the property, my lord, without any delay, my lord. Let them learn a lesson.
Yes.
Lordship may pass appropriate orders, but since the petitioner has failed to
Dismiss you. We will dismiss this writ petition.
Lordship, as your lordship pleases.
Okay. But Mr. T. Chakrabarty, learned counsel for the petition. Also heard as Chamaria, learned counsel for the
Bank.
respondents 1 to 3 within bracket UCO Bank. On and Miss MS MB Bora. RB Bora. RB Bora, learned government advocate Assam for the respond number 4. Para. On 17/11/2023, when this matter was taken up for motion, in the motion stage, this court passed the following orders. Page, you quote from the order. A to A. Stop. Today, when the matter is taken up, Mr. S. Chamaria, counsel for the respondent bank, submits that the petitioner has defaulted in making payments. Has defaulted in making payments as stop. Para. Mr. T. Chakrabarty, counsel for the petitioner, submits that the petitioner could not make the payment as directed by this court, as he could not arrange the set amount within the specified period of time. Stop. Para. This court passed the order dated 17/11/2023 on the declaration of the petitioner that he would be paying an amount of ₹5 lakhs to the bank on 18/11/2023, and the remaining amount of the FITL on or before 20/11/2023. This court further direct. No. The petitioner's firm also assured this court that the term loan will be paid on or before 15/12/2023. It was on the basis of the assurance given by the petitioner that the order dated 17/11/2023 was passed. We are appalled by the attitude of the petitioner in misleading this court by making false statements, by giving assurance that specific amounts would be paid on specific dates, and he has failed to do the same, only on the ground that he could not arrange the amount as assured before this court. Stop. Para. In that we have the matter common, as the petitioner has defaulted in his assurance given before this court, we dismiss the present petition. Stop. The interim order passed earlier stands rejected. Stop. The respondents are directed to proceed in accordance with law against the petition.
My lord, only respondent number 4, lordship, lordship, only one line that he may be directed to do the needful, my lord.
The respondent number 4 is directed to do the needful
The needful to recovery of
in accordance with law against the petitioner.
public. Item 2. If
May I please, your lordship. My lord, the petitioner husband, my lord, rendered service, my lord, for about 18 years, my lord. Out of which, my lord, his service 7 years, 1 month considered as pensionable service. So, my lord, accordingly, my lord, his pension was rejected as it was, my lord, not fulfill the, my lord, required terms for pension, my lord. Kindly see the impugn order, page, my lord, 51.
Yes.
My lord, page 51. So service rendered only 7 years, 1 month, 5 days, qualifying service, which effect from 25/3/1998 to 34/2005. The minimum qualifying service for eligibility of pension for a regular government servant is 10 years as per the rule 30 of the service pension rule 1969. Here the, my lord, petitioner's husband appointed in 1981. When the college was in a venture stage, my lord.
This is a writ appeal.
No, my lord. Is a writ petition rule has been challenged, my lord.
You are challenging the rule.
Yes, your lordship.
Which rule?
Rule, my lord, Assam college employees provincialization rule, my lord, rule 2A, B, C, and 3, my lord.
Okay. Yes. Yes, but
Lordship, at this stage, Lordship, let notice be issued, Lordship.
but Mr.
M. Islam.
M. Islam, then the council issue notice. Who appears for the respondents?
Lordship, I am appearing for 1 and 4.
Mr.
D. Upamanya,
D. Opamanian, then the standing council,
Higher Education.
education department. Appears for respondents 1,
And 4.
1 and 4. Pension, MS, S. Konwal, then the standing council pension department. Government advocate appears for the respondents 2, only 2. Finance, Chalia, A. Chalia, then the standing council finance appears for respondents 3. Only 3. 3.
Lordship, I am for 5.
And Mr.
RK Talukdam.
R.K. Talukdar, Leonard Council. The standing council, accountant general, appears for respondent number 5. Petitioner to take steps for service of notice on respondent 6 and 7 by registered postally within 1 week. List after 4 weeks.
Highly obliged, Your Lordship.
For admission item 3. Highly obliged.
May it please your lordship. Lord, although this matter is initially, this is like pursuant to an incident of mob lynching in Arunachal Pradesh.
Yeah.
Now, this honorable court, my lord, expanded the scope of the instant PIL. Now we are concerned with like, Lord, maintaining the e-prison app and installation of CCTV camera in the police stations and, my lord, monitoring or, my lord, preserving the data in a centralized system. On the last occasion, my lord, government of Arunachal Pradesh, Mizoram and Nagaland were supposed to file an affidavit. That is yet to be filed. So far as Assam is concerned, Assam filed an affidavit, but I raised this, my lord, objection that the integration in the e-prison app, my lord, there was a time lag of around 48 hours.
Yes,
It has to be in real time.
none of the states has filed. Assam has filed. Is that on record? On the e-prisons app.
Yes. So there is a time lag of around 24 to 48 hours in collating the biometric data. It has to be in the real time. So they have to work on it and bring it to the real time.
Yes. There's a time lag of 24 to 48 hours. Why?
Well, Malad, it depends on the central project now. Please, Malad, we've already mentioned in paragraph 3 and 4 of the affidavit,
That
my lord.
app-
Yes, my lord. And a response is awaited, my lord. If the central project is, my lord, is completed, then all the states will act upon it, my lord.
How about Nagaland? How much time? Kalita?
The Mizoram also, Lordship, I mean, the elections was where elections was there. Election was there, so we could not get proper information. But as far as Lordship, that CCTV cameras are concerned, that we have been told that those have been installed. But biometrics and all.
About the e-prison
That thing, Lordship,
software?
that Lordship, I'll need some time for getting the proper instructions and file an affidavit.
Arunachal?
We also request some time, my lord. We have received some instructions, my lord.
Oh,
Things are moving in the positive direction, but then we'll require some further time. My lord, our police stations are already, my lord, CCTVs are there. They want a central, my lord, system, my lord. And also on the, on,
CCTV is not the issue.
yes,
The issue is the e-prisons app.
my lord, even the other issues are also there, including that e-prison app, my lord.
But then we wanted an affidavit from you on that.
Yes, my
on
lord,
that
we'll
issue.
require some time to put it on.
Okay. 3 weeks.
It's like, four weeks.
But HK does, the understanding council for the Guwahati High Court. So, MS no, the state of Assam has filed an affidavit on 17/10/2023 pursuant to the order passed by this court on 38/2023. Stop. The relevant portion is reflected here in below. You quote para 3 and 4. Stop. Para. MSP Crow, the Additional Advocate General Nagaland, comma, Mr. BT Das, the Additional Advocate Arunachal Pradesh.
I'm Goswami, my lord, I'm VD Goswami.
Sorry, BD Goswami, Learned Additional Advocate General Arunachal Pradesh, and Mr. K. Kalita, Learned Additional Advocate General Mizoram, respectively praised for 4 weeks' time to file affidavit in terms of the order dated 38/2022. Praise a lot. List the matter again on, give a date up to 4 weeks.
4th of January.
January.
4th
Fine,
January.
Much
Deeply obliged.
Item 4.
May it please your lordship.
Yes, please.
Lordship, in compliance with your lordship's orders, the state government has filed an affidavit stating that nodal officers have been appointed and certificates from various institutions have also been called for, so that means they need to submit certificates on a regular basis with regard to the fish which are being imported as regards formaldehyde. But my lord, in this particular affidavit, it does not show that the tests which have been conducted, in those tests, the amount of formaldehyde in the fish is within the permissible limits. But it has been written that the original records may be placed before this honorable court at the time of hearing. So if your lordship peruse it, if it is within permissible limits, then my lord, my prayer in the PIL was only to the extent that the respondent should conduct a continuous monitoring of the fish market in Assam. And that is the basic issue in this matter. So if it is within the permissible limits, my lord, I leave it to your lordships to take a decision on it.
Yes,
My lord, we have, my lord, conducted, my lord, district-wise, my lord, test. That report up to, my lord, October 2023, we have, my lord. We have been original. If your lordship, my lord, want to peruse, my lord, history, my lord.
have you flagged it?
My lord. My lord, I have.
We'll take it up on Monday.
My lord.
We are appearing to one thing, my lord. My lord, in this case, I am appearing for respondent number 4, my lord. The entire PL has been cropped up upon a report from our college, my lord. Because on 8/23, my lord,
Yes.
this honorable court directed the state respondent, my lord, to furnish the entire pleading to us, my lord. But no, till then, my lord, we do not have any pleadings, my lord, because affidavit they have filed and other things, my lord. So, my lord, they may be, my lord, provided me the copies of the affidavits and report.
You are praying for?
Respondent number 4, my lord.
My lord, Nagaon College, initially when this PIL was filed, it was on the basis of newspaper clippings. And in those newspaper clippings, it was mentioned that Nagaon College had conducted a study. And as per that study, the fishes which is being imported in the state of Assam contain high amount of formaldehyde.
Have you given the affidavit to him?
My lord, the state government is supposed to provide it to them. I have already
I have received the entire affidavits filed by the petitioner, my lord. But my lord, for respondent, I am not receiving.
For the state government, they have not received.
So Sharma,
My lord. May I, my lord, permitted to talk with you? তোমালোকৰ এখন এফিডেভিটটো ইয়াতে আছে কি
আমি এফিডেভিট দিম
আমি তবে
how many affidavits have you
My
filed?
lord, my learned friend appearing for the respondent, which has been impleted, my lord, we have provided to them If required, my lord, I may be permitted to, my lord, serve a copy to performer respondent also. Since he is a performer respondent and sometimes, my lord, he may not appear, my lord. That is why that has not been served. Will
But my learned sector friend will serve me copy, my lord.
The respondent number, you are appearing for respondent?
I'm for, my lord.
Oh, Sharma?
my lord, I'll.
1, 2, and 3, the state.
Additional affidavit you've got from the petitioner?
Additional, we
Yes,
have.
my lord, I've served all the pleadings from my side.
Before that, your lordship may kindly see the prayer portion of the PIL.
That I've seen. At least let him have a copy.
I'll
Then
share, I'll share. My lord, whole purpose of the PIL, my lord, undoubtedly, my lord, the petitioner come before this honorable court with a very important issue, my lord.
yes.
That has been resolved now, and there is a, my lord, notification, and draft notification has already been issued. My lord, it is only placed for cabinet approval for frequent, my lord, and continuous monitoring of the formalin in the imported fish. That has already been done. My lord,
That is in public interest.
yes, my lord, that has already been done. As such, my lord, the entire, my lord, issues which has been raised by the petitioner has been resolved, my lord.
My lord, that part I agree that the state has indeed taken a lot of action after
The
the.
TK Mishra, Sharma. Then an additional senior governor. Shall furnish copy of the additional affidavit filed by the respondent number 3 on 10th August 2023, comma. The consolidated affidavit filed by the respondent number 3 on 18th November. No. How many affidavits have you filed? You filed 3, isn't it?
3, my lord.
One.
I have initially filed affidavit, then my lord, an additional affidavit, then consolidated affidavit.
Cancel that order. It was the.
My lord,
Sharma.
actually, the food safety department has also filed one affidavit. Fishery has filed one, then food safety, and then again 2 more. So from the state side, if I'm not wrong, 4 affidavits have come in total.
The fishery department, we have filed 3 affidavits.
Fisheries respondent?
Fishery respondent number, my lord.
My lord, fishery is respondent number 3.
3.
And food and civil supplies department had also filed one affidavit.
Who's the which respondent is that? Two.
Respondent number 2.
Who appears for food?
I am a representative.
Okay. Then you say Mr. DK Sharma, then additional senior governor. Shall furnish copies of the affidavit in opposition filed by the respondent number 2 on 30 May 2023. Comma. The additional affidavit filed by the respondent number 3 on 10th August 2023. And the consolidated affidavit filed by the respondent number 2 on 18th November 2023. To the learned counsel appearing for the respondent number 4 within
My lord, 22 days, my lord.
within a period of 2 days, within a period of 3 days.
7-1, 2.
This matter. Again, 6. We'll have it on 6.
My lord,
6.
Yeah.
My lord.
deeply obliged. my lord.
Number kita lagi mana? Prabhat Kumar number 2 incomplete. Obligement. Kumar number 2.
May I please, your lordship? First, I am for the respondent.
Who appears for the appellant? None appears for the appellant. Mr.
AJ Amuli.
Is it Ganguly?
Tamuli,
Tamil. Then council appears for
respondent number 1.
respondent number 1. And the other respondents? Bar Council of India, Bar Council of Assam. Please, after 1 week.
Obliged.
Item 6.
May I please, Your Lordship?
Since the council was appearing for an adjournment.
Lordship, service condition in respect of the, in item number 6, Lordship, of the appellants, there, it is different from the other matters, Lordship. The appellants
What's
here,
the
in-
difference?
Lordship, here appellants belongs to the 6 schedule
Who
area.
appears for the respondent?
Lordship, I am appearing for 2, 3 and 6.
Dima Asau
In
district.
item 6.
Yes, Lordship.
6. Dima Asau district, Lordship, and their service condition was different from the other parts of the state, Lordship. Because they were initially appointed by the North Kasai Hills Autonomous Council, Lordship. And since education is a transfer subject, so dear,
Respondents 2, 3.
2, 3 and 6, Lordship.
How about 4, 5,
And for 7.
7? Accountant General. Finance. Pension. Government Advocate. Yeah, appearing.
And thus.
Are you ready?
Lordship, these are matters which are pertaining to new pension scheme and old pension scheme.
yes.
And a separate education bench has been formed, my lord. So, this matter should be taken up with those benches because, my lords, they were all, at the end of the day, they were all teachers, my lords. So, Honorable Division Bench only has formed a special division bench to hear all these matters. So, this matter should be taken up with those other matters, my lords. Because, and those matters have not come up, my lord. So, they operate. And the judgment which is under challenge, my lords, other teachers were also clubbed in that writ petition, my lords. In those writ petitions. That common judgment is being challenged over here.
Which common judgment?
Lordship. The judgment dated 31/3/2020.
Is number 143.
143, that's Lordship. Here, the honorable single judge, my lords, all these are teachers, my lords, but they were differently, they were appointed in different manners, my lords. There were access teachers, there were OBB teachers, and my learned friend also was one of the classifications, my lords.
Lordship, my 236. This is the 6th schedule area, Lordship. Others are different, Lordship. But my case is I am from the 6th schedule area of Dima Asau, Lordship, and they were appointed by the council.
Yes.
The honorable single judge has rejected the prayer on the ground, Lordship, rejected the prayer for regular pension under pension bill 1969 on the ground that their past service cannot be considered since their service was under non-pensionable establishment. So it may be segregated, Lordship.
No, Lordship, but there again, like they are the teachers, my lords. So all these aspects have to be considered.
Lordship, but my case is Lordship different because they were regularly appointed under the council.
But then you're also a teacher, isn't it?
Lordship,
Yes,
but Lordship, others cases are different, Lordship, but my case is that we were regularly appointed and it is admitted by the Dima Asau Council, Lordship, that we were appointed against sanction post created by the council. So their past service will be considered,
Okay,
Lordship.
when is your senior coming?
In the month of January.
No,
Lordship,
we can't wait till January.
This appellants have already been retired 2020. Some from 2016 to 2020, in between 2016 to 20. So it may be Early hearing is required.
Lordship,
Lordship.
then I would-
One has already expired, Lordship.
A date may be fixed, Lordship, because Mr. R. Bharat Pujari was also looking after these matters, my lords. If my lord, any date after 2 weeks, my lord.
It may be admitted, Lordship, at this stage after the
But
It
Lord-
is already admitted.
Lordship.
Lordship, for hearing a date may be fixed because Lordship, there were 7 or 8 batches of teachers, Lordship.
Okay.
The teachers were,
On
commissioner was
request
also one of them.
made on behalf of your senior's name,
KDB. My senior, on behalf of
Ms.
KDB.
KDV.
Lordship, my judgment is also passed separately, Lordship, from other.
No, Lordship,
At
it's in the same judgment.
Page 236.
Page
That
2,
I've seen.
it's the same judgment, Lordship.
So judgment is common judgment, Lordship.
So-
Separate condition has been
So let us see
considered,
on the
Lordship.
next date fix.
But
Lordship.
Is the matter again on? After 2 weeks, give a date,
19.
19.
19th December. Make sure she comes.
Item 11.
May please your lordships.
Yes.
My lord, writ appeal against the judgment and order of learned single judge.
Hmm.
Lordships, this caveat is filed, lordships. Caveat is filed by respondent number 1.2 and 1.3, lordships. My learned friend appeared on their behalf, lordship. Lordship, my father was the occupancy tenant, lordships, in 1960, lordships.
No.
And lordships, he was issued with Khotian lordships, Khotian number 54, lordships. And father expired in 1991, lordships. And thereafter, lordships, we have applied for Khotian, and accordingly, lordships, Khotian was issued. Thereafter, lordships, in 1995, we have applied for ownership rights, lordships. And accordingly, lordships, these notices were issued. Both the parties appeared, lordships, and after hearing the parties, lordships, this ownership rights granted to us, lordships. And lordship, this additional deputy commissioner has directed to deposit 146 rupees before the treasury, lordships, and accordingly, lordships, it was deposited. And thereafter, lordships, this gazette notification was published, lordships, and accordingly, lordships, our name, appellant's name appeared in the Assam Gazette, lordships. Now, immediately thereafter, lordships, this, in the meantime, lordships, this respondent, Bahar Ali, lordships, he preferred the appeal, lordships, before the Honorable Assam Board of Revenue, lordships. In Assam Board of Revenue, lordships, after appearing, lordships, it was remanded back again to the learned ADC, lordships, to have a fresh examination, lordships. Lordships, at that time, both sides, lordships, this, it were examined. I have produced 3 witnesses, lordships, and Bahar Ali, respondent, lordships, he produced 2 witnesses. After perusal of the evidences and also report received from the learned circle officer, learned circle officer categorically stated that the land in question, it is in our possession, lordships. And after obtaining the report from the learned circle officer, the learned ADC, lordship, passed the order in my favor, lordships. Lordships, thereafter, lordships, again, Bahar Ali, lordship, respondent, he preferred the appeal before the Assam Board of Revenue. And that was allowed, lordships. And thereafter, lordships, we have filed a review petition before the Assam Board of Revenue, and that Assam Board of Revenue has dismissed our review petition. Thereafter, lordships, in 2010, we have approached before this honorable court challenging the order passed by the Assam Board of Revenue, lordships. Lordships, in 2017, lordships, the then learned single judge passed the order, lordships. It is reported also in GLT, lordships, that order which was passed by the learned Assam Board of Revenue is unsustainable and remanded back to the learned ADC to have a fresh discussion in respect of medical certificate issued to Bahar Ali Lordships. Bahar Ali has obtained a medical certificate from medical officer and health officer Lordships. Lordships, in the meantime, Lordships in Bahar Ali expired Lordships. And also, Lordships, their legal years, Bahar Ali's legal years prefer the writ appeal Lordships before the Honorable Court, Division Bench Lordships. Lordships, as Bahar Ali expired and these legal years of Bahar Ali could not get the scope for contest, so the case is remanded back again to the learned single judge Lordships. Lordships, this learned single judge passed the order dismissing the writ petition Lordships. Against the writ petition Lordships, I have approached before this Honorable Court by filing this appeal Lordships. Lordships, since 1960 Lordships till today, last 64 years Lordships, I am in possession Lordships. We are the farmer Lordships, and Lordship, this land belongs to Pamohi Lordships. On the other hand, Lordships, Bahar Ali, he is staying in Gandhibasti Lordships. From Gandhibasti to Pamohi Lordships, it is about 30 kilometers distance Lordships. Lordships, there is a provision Lordships, if at all somebody is having land, it has to be within the circle of 5 miles Lordships. Lordships, as the order is passed illegally by the learned single judge Lordships, I have approached before this Honorable Court challenging the said order Lordships. Lordship, that order earlier order Lordships, page 153 Lordships. 153 Lordships. Operative portion Lordships passed on 8/9/2017 Lordships. Operative portion, page 167 Lordships. 167. In the aforesaid premises, the conclusion of the learned Assam Board of Revenue that the order of Additional Deputy Commissioner dated 9/7/2004 is to be set aside merely on the basis of certificate issues by the 9/11/95 of the SDMN and HO is found to be unsustainable Lordships. Lordships, now it is remanded back Lordships. It is remanded back, and Lordships, this learned single judge passed the order on Lordships, Lordship, during the pendency of the writ petition Lordships, case 178 Lordships, order passed on 25/7/2023 Lordships. Case 25/7/23 Lordships, case 179 Lordships. Here it is, Lordship, second paragraph. The writ petition was disposed of by coordinate bench by a judgment and order dated 8/9/2017. It transfers from the order dated 12/9/2017 of the administrative officer judicial that after disposal of the writ petition by the judgment and order dated 8/9/2017, the record priority case number 66/1995, case number 188 RAK 1995, case number 117/2004, and case number 13 RA
RVW 2007 were sent back. The said judgment and order dated 8/9/2017 has been set aside by the division bench by the judgment and order dated 4/2/2019 in the writ appeal. In view of the restitution of the writ petition to its original number and after hearing the learned counsel for the parties at some length, the court is of the view that perusal of the records of priority case number 66 of 1995 and case number 188 of 1995, case number 117 of 2004, and case
Yes.
number 13 RA.
What happened after this?
Lordships, this record, priority case, as on today, when this order was passed by the learned single judge, Lordships, this order was not available, Lordships. I placed before the Honorable learned single judge that this is the most important record because this is the original record. So it has to be brought from the learned additional deputy commissioner. Lordship, without that, Lordships, the order is passed by the learned single judge. Lordship, these two records are available. Three records are available. That is order of Assam Board of Revenue. On the other hand, this is the vital record, Lordships. This priority case number 66 of 1995, it is the vital documents. It is the original case. And in that case, Lordships, it is clearly mentioned. And also there is a report from the learned.
We can issue notice, no, sister? Sister. Issue notice and see later. Yes, who appears on the others? Are you the Kivita?
Yes, ma'am.
Yeah, Mr.
Mr. A.C. Sharma.
But A.C. Sharma, the counsel for the Kivit. We'll issue notices, then we'll consider it later on. But Mr. R. Sharma, the counsel for the appellant. Issue notice. Mr. A.C. Sharma, the counsel, enters appearance on behalf of respondents 1 to 1.5.
Accept Board of Revenue, my lord.
1 to 1.5.
Yes.
The notice on the Assam Board of Revenue Guwahati is withheld for the time being. There's no point in issuing notice to the Assam Revenue Board.
Yes.
Why have you met him a party? Oh, please, doctor.
The records may be called. Records of the priority case number 66 of
Who has the records?
DC in the Court of Additional Deputy.
Is the Deputy Commissioner party here?
Lordships, Deputy Commissioner is not with the party, Lordships.
Was
but
the Deputy Commissioner party in the writ proceedings?
writ proceeding, it is not their Lordship. Assam Board of Revenue was their Lordships. Order was passed by the Honorable Court, Lordships, and also special messenger was sent from this Honorable Court, Lordships. And there is a office note also that in spite of sending the special messenger, priority case number 66 of 99 have not come, Lordships.
That
Office
record
note is
is
there in the
important,
original record.
That record is essential because by that, in that case, the ADC passed an order recording their ownership over the land. So I am the title holder of the land. Let them directed to make ADC and deputy district commissioner.
How can they do it in the appellate stage?
In that case also the record may be called for because that is the vital record.
Call for the records of within brackets Roman 1, priority case number 66 of 1995, comma, Roman 2,
From the court, from the office of the additional deputy commissioner.
all these cases.
Yes.
Lordships, this Rayati case number 66 of like
That is
1995.
sufficient, that is enough.
Lordships, these other 3 records are available before His Honorable Court, Lordships. Because when
Whether
this
the
court-
records have been sent back.
The other
Lordship,
two
all the-
cases, the Board of Revenue cases are not necessary. Because
Okay,
this
call for
husband,
the case of Rayati case number 66 of 1995 from the office of the
deputy district commissioner, Kamrup
District
Metro.
Commissioner, Kamrup
Metro.
Metro. List after 6 weeks.
Lordships, I have a miscase, Lordships, IAC, Lordships.
For what?
Regarding Lordships, stay and I am in possession as on today, Lordships. I may not be disturbed.
Status quo as on today shall be maintained till the next 15 days.
I never.
Item 12.
Lordship, by filing this writ appeal, I am challenging the impugn order passed by the Honorable Single Judge in WBC 6508/2023. Lordship, I kindly peruse the synopsis of the writ appeal for proper appreciation of the matter. Irrigation Department invited online total 300 crores of tender, confining to only 10 groups. Kindly. Now, kindly see page 5, serial 6. That is the projection of different estimates as on RTI revelation.
Yes, Subramani.
Lordship, my humble submission would be, Lordship, he has no locus to, Lordship, file this writ petition, Lord. He is not a participant in the tender, full tender process,
Lordship.
And it is not a PIL, Lord. It is a writ petition, Lordship. He has some right to file a.
Is it a writ petition or appeal?
Lordship, come out of the writ petition, Lordship.
Lordship, locus will come when? Locus will come only you, in case of 10 bidders, you divide the work among 100 bidders. What is the purpose and motive of filing the writ petition? Basic purpose and filing of motive the writ petition, that the respondent irrigation department has clubbed many small estimates to make it big with a pre-bid understanding with some, the instruction of the top competent authority. And 10 bidders have come to the contact to the competent authority, and 300 crores of rupees are involved on 10 packages. Means 10 contractors are eligible to participate, and thereby curtailing the respect for professional right of 100 bidders, eligible bidders. So RTI reveals what? RTI reveals says that how 1 crore 25 lakhs, 1 crore 39 lakhs, 1 crore 16 lakhs. The small estimates are clubbed into a big one. The purpose will be find out. And secondly, there's a clear order, there's a clear, Supreme Court verdict in respect of public policy. Let me kindly peruse these two things.
Lordship is aware of Lordship NG projects, Lordship, judgment, Lordship. This is a public government tender, Lordship.
Motive is more important. Motive of the, these are the, I have flagged there.
What case is this?
This is Supreme Court, that's Allahabad High Court. Once Allahabad High Court, there's verdict is there. That is serial para 9, section 10, section 13, section 14. I have marked yellow mark. That is the intention of the respondent irrigation department with the hidden agenda. They club the small estimates to a big one and to make it a 10 groups. Why not 100 to 100 groups? What is the difficulty? An honorable single judge, without allowing me to, complete my submission, only 40 seconds. In against 40 seconds of submission of 4 pages of judgment. At least notice to be served to the department. What is what not. At least some review there.
What is wrong with the judgment?
The judgment, they said that it is a what court they say. The judge, honorable single judge said that it is they said the court has absolutely no expertise to make an assessment as to what would be the arena or area of the contract, what would be the scope and nature of the other modalities which are required to be there to management tender. So if the honorable single judge does not have the expertise, how my writ petition is dismissed? Without expertise, honorable single judge could have hired the expertise from the department. What
are you submitting, counsel, Mr. Petitioner?
As I'm a contractor.
What are you submitting? If you don't know how to submit, you get a lawyer.
No, I'm a petitioner person.
I know that. You should know how to submit before the court.
Sorry, sir.
The single judge gave you how many minutes?
Only 40 seconds.
40 seconds. I'm going to give you 2 seconds.
Sorry. I could not complete my submission. That is the problem.
What are you submitting about the expertise of the court? That is not for you to question.
Sorry. I beg your pardon.
I don't understand. Yes. I don't think anything is wrong with it. Yes, Subramaniam.
Lordship, the landed court in Gujarat has passed a regional order, Lordship. And for my
Let us see the order.
Lord,
I've not got the time to go through this.
paragraph 4 would be Lordship, really. Page 130.
Yes, yes.
So Lordship, this at para 7, Honorable Single just said that tender matter is a state subject. It is admitted. But illegalities, irregularities,
Did you participate in the tender?
no, because I have not been given the scope of eligibility. If it would have been made smaller group, instead of making 30 crores one single package, then it didn't have, it would have, I would have.
Why don't you get some laws on this issue and then come back? We don't want to throw you out at the first instance. Get number 1 on your locus. Number 2, on whether the state government or the state authorities, whether to club up or to fragment tenders are within your domain or not. That you can see some case loose and come back. I'll give you some time.
But is it preserve the Lordship or notice can be served for get proper?
I'm not issuing notice at this stage. I'll give you some time. You can study the case laws and come back.
As the court pleases.
Yes, or you can take the help of some lawyers.
But it is against the public policy, which is under Section 23 of Contract Act. That is Section 23 of Contract
That
Act.
is a different thing. What I'm stated is that first come with your locus. Number 2, whether the state government, they have the authority either to divide or to club up particular items and
Lordship, there is no single word, different words, different places. RTS different word, different places, not a single word. RTI regulation is there.
that we have seen. We've read the judgment also. We have seen the RTI information. Mr. B.K. Bhattacharjee, learned petitioner in person, is allowed. How much time do you want?
Give 15 days time.
Is allowed 2 weeks time. 2 weeks time to prepare the matter. To prepare the matter. To prepare his case. Stop. Please, after 2 weeks. You want a date fixed? You want a date fixed?
Yes.
Give a date.
21st December.
Mr. B. Yeah, sorry, A. Wadia.
N for Narayan.
N. Wadia.
For the respondent.
Standing Council, Irrigation Department.
How like that?
For admission, item 21 from supplementary list.
Meet please, your Lordship. The issue before your Lordship is whether Section 3E of the National Highway Act or Section 26 of the Control of National Highway Land and Traffic Act would be applicable in the present case, my lord. What the background is this, my lord, where the petitioner had purchased a plot of land measuring 2 bighas, 2 kathas. What has happened? Before they could purchase, my lord, there was a notification by the National Highway Authority to acquire the part of the land. They had an understanding with the landowner that they would pay the amount whatever they would, my lord, get. Subsequently, my lord, the land was acquired. The entire procedure under Section 3 was followed. Notices were issued. Possession was taken over, my lord. Thereafter, my lord, the petitioner constructed its boundary wall, my lord, and it's constructed its shed and factory. It's been operating. Operation has started commercial production way back. Now, all of a sudden, my lord, in 2018, the officials from the circle officer and the National Highway Authority came and informed the petitioner that their boundary wall, they have encroached the part of the National Highway and their boundary wall and the factory shed would be demolished. At that stage, my lord, we approach your lordships. Lord, we did not have the entire detail of the quantum of the land that has been acquired. On a rough estimate, since the mandal and the lat mandal and the circle officer demarcated it, Lord, we took it that way. And we were under possession of 2 bighas of land, Lord, that we subsequently, Lord, we measured our land. What happened thereafter, Lord, your lordship was pleased to protect us. And, Lord, during the pendency of this case, the National Highway Authority filed their affidavit, which shows that, Lord, an area of 0.072 hectares, which amounts to 2 kathas,
13.8 lessons is being under has been acquired, and we were under the possession of 2 bighas. So basically an area of 13.8 lessons, what that we are in excess possession, Lord. That is admitted position so far it has transpired, my lord. During the pendency, my lord, a joint measurement survey was also conducted, my lord, but we were not allowed to sign C, my lord. In fact, our my representative signature was also forged. Lord, when the matter was taken up by learned single judge, Lord, we raised the legal issue before your lordships. Lord, our prayer in the writ petition was very simple, that whatever action you do, you give us a notice under the law. Lord, that is our prayer in the writ petition. Lord, in fact, if your lordship would see, after the control of 2002 Act was enacted, Lord, there is a provision under the Act for issuing notice to the encroachers. They have a right to determine whether what portion and how it would be done. The entire mechanism is there. But if your lordship would see the impugned judgment, Lord, para 9, Lord, the submissions that was made on behalf of the petitioner at page 82, my lord. Page 82.
Yes.
My lord. In the backdrop of the above, this court therefore take note of the respective container. Mr. So-and-so, learned counsel opinion with the petitioner submitted that if the petitioner are in the occupation of any land which were acquired, the petitioner can only be disposed by following due process as per the procedure stipulated in the Act of 2002, and more particularly referred to section 26 of the Act of 2002, which provides the due procedure of law. It is therefore the submission of the learned counsel on behalf of the petitioner that the state authorities have no business to demolish the boundary wall of the petitioners in the manner which has been sought to be done, and it is only the highway administration constituted under section 3 of the Act of 2002 or officer authorized by the highway administration who can act as per this. He further submitted that the highway administration, as per section 23 of the Act of 2002, is also required to maintain record in the prescribed manner in respect of all lands of the central, and it is on the basis of those records the highway administration or the officer authorized can act in terms of which section 26 of the Act. This contention was refuted by the National Highway Authority, saying that we have not made a party to the highway. But we are not required to. Whoever the authority would issue a notice, if you would have grievance, then only what we say is National Highway is the property of the central government and the National Highway Authority is the owner. Therefore, they have to follow the procedure. These contentions of the petitioners was not even was refuted by the learned single judge, and the learned single judge was of the view that section 3 of the Highway Act provide for procedure. My lord will kindly come to page 87.
Yes.
My lord, last 4 lines of the first paragraph. Was acquired by the petitioner, the circle officer Rangia Circle by himself along with revenue officials to carry out the said demarcation and identify the said plot of land and take position in terms of section 3 of the National Highway and hand over the same to the National Highway Authority. The representative of the National Highway of the authority are directed to be present on the date and the time fixed by this court hereafter. The said demarcation will be carried out on 13/11/2023, tomorrow at 11 AM, my lord. If your lordship would kindly have a look at the National Highway, the control of
When
traffic.
was this order passed?
My lord, on 16/11, my lord.
Basically, this notice.
No, my lord. If your lordship would, because there has to be a notice by the highway administration. I have no notice at all, my lord. What the learned single judge has said, my lord, that they will go by themselves, demarcate it, and my lord, the action would be taken. My lord, I'll rely upon the judgment of the apex court, my lord.
1 minute, 1 minute. You are given liberty to participate in the said demarcation proceedings.
My lord, my contention before your lordship is the control of National Highway Land and Traffic Act will come into play, my lord. My lord, the highway administration is the authority who has the records. My lord, if they find out that there is excess land, my lord, they have a procedure of issuing notice. Then I have a right to respond. And if they find I am in excess position, they can take action under 26. I also have a remedy of appeal under the tribunal constituted. But if this exercise is not done, my lord, my right is also taken away. On that very issue.
Yes, Sharma.
My lord will take note of this judgment of the apex court for a moment, my lord.
My learned
Two.
National Highway Authority, moreover, I was in that because post-friend was.
My lord, the similar issues arose in this case. What has happened, my lord? Under the Tamil Nadu Act, my lord, notice was issued. The writ petition was filed, writ petition was dismissed, the High Court dismissed the writ petition, my lord. Thereafter, it was taken in before the apex court. The issue raised was, my lord, whether the, my lord, state authorities under the National Highway Act can act. But the apex court has let down the law, my lord. After the enactment of the 2002 Act, it is only this Act, my lord, which would be taken, my lord, should be applicable for the unauthorized occupant. Extra copy. 2000
Yes, Varun.
Yes, my lord. May I please your lordship? Its matter is not exactly that manner. What happened, my lord? This entire land was acquired for construction on National Highway under the provision of National Highways Act 1956, my lord. And accordingly, under provision of Section 3A, notification was issued. Thereafter, declaration was after provision of 3C of same Act, 21 days are given for filing objection. If no objection comes, then we go for declaration 3D under 3 provision of 3D. Thereafter, we take possession under position of 3E. It becomes absolute owner property of the government. Thereafter, under provision of Section 3G, we are required to pay compensation. Accordingly, my lord, this entire procedure that is under Section 3A, 3D, and under the provision of 3G, he has received an amount for compensation for 2 kotha, 13 lessons is in hectare 0.072. That is, he has already taken money for that. But what happened, my lord? According to his own submission by here, that he has handed over us only 2 kotha land out of 2 kotha, 13 less or something. That is. Now, my lord, we'll come by this one. According to him, that simple, he's drawing attention before lordship that this judgment is wrong because of he was not given opportunity by issuing notice under section of provision of Section 26, subsection 2 of 26 under Traffic Control Act 2002, my lord. Here, definitely, but lordship have to go back to his writ petition. He has filed a writ petition, simply lordship may prayer, your lordship will see his prayer now. First he has prayer, your lordship will get in.
26.
Huh?
Page 26.
Page 26. My learned is helping, very nice. Lordship, it is independent, lordship got it, because we have to go by prayer and his submission here. In premise or aforesaid petition, may your lordship would be pleased to admit this petition call for record, issue rule calling upon the respondent to show cause as to why read in the nature of mandamus, that to mandamus should not be issued directing the respondents that boundary wall of the factory premises of the petitioner should not be demolished and they should not be evicted from part of their factory and without following due process of law. After hearing the parties, please to make this one. Now, my lord, no schedule of the land, no notice had been here as per prayer, no notice. Anyhow, here your lordship will get it. Now, petitioner, even we have not gone that part also because we wanted to help. Respondent he has made us, National Highway Authorities, represented by General Manager, Project Test Pool. We do not have even Test Pool. We have these projects come under PIU, Project Implementation Guwahati. But anyhow, we did not come on objection because of this. His prayer, he should get justice on that point, rightly. If it has been really, he's been affected, we'll definitely help. Then I filed a affidavit, my lord, on behalf of National Highway Authority. I have clearly stated that under the provision of what I before that submitted, that under the provision of 3G already we have paid. Now, according to his submission, he's saying that I have come to know now only that I have, here a judgment is reflected, that it is land, though I have 2 bigha, 2 kotha,
some lessers I have purchased out of that 0.072 means 2 kotha some things. But he has given me 2 kotha. He is admitted fact. This is admitted fact. He is admitted fact. That means we are given less, 13 lessers. These cases come up. Thereafter, Honorable single judge has said that, okay, go for demarcation. Up to that point, he was silent. He was fully agreeing with that. Go for demarcation, let us see what is real result. Then we have gone for demarcation. According to him, his advantage not present. Anyhow, that will come later on. But this is demarcated, it is seen. Say, yes, 9 lesser land is, he has extra acquiring. He is in the occupation of that. Thereafter, he has come by way of filing affidavit in reply, stating that, here paragraph is there, that it is admitted, may not be admitted, but like that he said, this notice will be applicable now. According to him, then no, you would have procedure would have been now, state authority doesn't have rule on that point, because it is the authority, National Highway Authority under section 2, subsection 2 of section 26 of Traffic and Control Act 2002, you should give notice. One thing, by way of affidavit reply, can he improve the case? Because his notice, here it has been said, who will do this job? To whom? Who is the authority? He is saying that I have no concern with the authorities, whoever has some time affected from my land. But being you are coming to before this honorable court, when you are coming to court, when you are attacking the section of section 2 of 26, here it is clearly written, it is the administrator. Administrator word is there. Then you would have amended the writ petition or returned the petition. Then would have come, Lordship, I'll come. He has not done so. He has not done so. He has made the same. Now he is saying by way of affidavit, no, this notice is illegal. Now, anyhow, my lord, thereafter, demarcation was carried out according to his own allegation that his repentant is not available. That is why now only measurement is there, my lord. Already court has taken lot many days for exercise entire disposing the cases, considering the landlord question, because interim order was protecting him up to that last judgment from date of motion onward to till this one, he was getting protection. Now, honorable court has rightly passed an order. You go on tomorrow, measure it. You be also there, because his allegation was there that I was not present, because my repentant not present, forcibly signature was taken. No affidavit was filed by him. It's all been reflected here, my lord, judgment. It is clearly reflected. Now, my lord, by only now also not admitting, assuming that if notice is served by me, according to him, I should serve. What will happen, my lord? Again, I have to take help of circle officer only, because land of authority I have to take. Again, I have to go for measurement. I have to go for again measurement. He admitted fact that he is acquiring more than purchased land. He has whatever he have taken money. He is the 13 lesser. He is acquiring extra. That is admitted fact. Now there is a question of no stays can be granted, my lord. Lordship, this entire judgment, if we go through, you'll see there's no defect, any department. No, there's a full yes and nay decision. Not that this is being any lacuna on this point. Rightly, it will be discussed, entire judgment, my lord. It's my humble submission before Lordship. Yes, Lordship, that judgment he is preparing. We have also this, we have all contesting, because when 26(3) is not, service notice is not given by proper person, but he has not made an administrator as a party itself. After knowing to know, by way want to improve by affidavit in a reply, he want to improve the case. He would have very well withdrawn the case that time. He would have, and he doesn't know who is administrator also, I think. He's supposed to know when you're coming to court, my lord.
Yeah.
My lord, there cannot be any stay, my lord. Let them pay measurement, because it is a national highway project. Supreme Court clearly saying in any case, if Supreme Court election dispute regarding land, you cannot stop these things. Only regarding payment, and if you have, there is a provision for payment, and of this one you can get it. But here the complete clear case he has acquired. He is an encroacher.
My lord.
My lord. My sir,
Just 2 minutes reply. But, my lord, I am saying all, so far as factual determination is concerned, there is no dispute at all. My lord, 3E would be applicable at the time of invocation of the, my lord, acquisition.
No, but then you have been compensated, isn't it?
That's true, Lord. Even I'm admitting, Lord, I'm in excess of land. I'm not disputing that. My issue before your lordship is that there is a process under the Act of
That we
2002.
have understood. That we have understood.
So, Lord, therefore,
So you are under your agreement on 2 points.
my Lord,
Compensation you have received.
yes, I have.
You are in excess of land.
Yes. Now issue is, my lord, if your lordship would see the record of the learned single judge, my lord, there when the writ petition was moved, I have made a statement
Why
also.
did you accept the compensation if the procedure was not done in
No,
accordance
it,
with law?
my lord, it was, therefore I'm saying, my lord, it is for them to acquire. My lord will see. They have followed a process. How 2 kathas of land, which is a larger part they have acquired. They have acquired by issuing a notice under 3E. Now, if they acquire less at that point of time, it's not a case where I had resisted. It is for them to acquire. They had issued a notice. Now, part of my land has been acquired. Most part of it. Only some part is left. It was their duty to take that. To measure.
One issue is that you knew that there was a procedure laid down on how the land is to be acquired, correct?
Yes, that was done.
That you knew that they did not do, but when they came with the compensation, you accepted the compensation.
Yes, I
correct?
did. I did.
Why did you accept the
But
compensation?
I did because, my lord, earlier only, my lord, that boundary was, my lord, demarcated. My lord, they had demarcated in 2008. Compensation was paid in 2012.
On one side, you said there's a procedure for paying compensation for
No, I'm not disputing the procedure for payment, my lord. What I am saying,
for acquiring land and for paying compensation.
yes,
correct?
but that procedure would.
On the other side, you said they did not follow that procedure.
No,
correct.
I'm not saying. What I'm saying is, that they did it partly. Once you have acquired 2 kathas of land and it becomes your land, even assuming my excess land is part of their land, then they have to maintain a record in terms of section 23 of the Control Act. That is the apex court has said, my lord. And now, my lord, when they maintain a record, it is their duty to see that my land has been encroached or not. Once they find out that my land has been encroached, they issue a notice. In this case, my lord, no notice, nothing. All of a sudden, my lord, can somebody come and threaten me that I will demolish? What I'll do? I don't know who has come, how it has come. I know it has a land acquired by National Highway. And if, therefore, my lord, there has to be a notice which the apex court has said. My lord, when this repeat, my lord, when the instruction was placed, it was placed before your lordships. This is there in the record of the learned single judge that I have encroached 2 kathas 17 lessas. Now it is come that I have encroached 2 kathas 13.8 letter. My lord will see the photographs. Exactly outside my boundary, there is a pillar of NHAI.
Even your photograph was discussed, I think.
Yes, yes. It is they who has implanted that code. But how, as an individual, I'll say if they have not acted in terms of their own act, they have been sitting all along for 10 years, my lord. My friend has said encroacher, unauthorized occupation that has been defined under the 2002 Act.
You only admitted.
Yes, I am admitting it.
The encroacher, you only admitted.
I am admitting it. Therefore, my lord, encroacher's definition and unauthorized person definition is under the 2002 Act.
Here, my lord, only 2 questions. Either he let him accept as the encroacher.
I am accepting that. I am accepting, my lord.
Encroacher, whether encroacher will be entitled for any stay for construction of delay, especially relief act clearly says, my lord, section 20. Clearly says, my lord,
para 13 of the justice.
Clearly says that you cannot be given stay for this, especially construction of national highway, that too.
Specifically, I am not a civil suit, my lord. I am filing a writ petition.
That is why you should have come in proper manner. Whatever
Yes, my
manner
lord.
is required.
Para 13.
Para 13 is very much clear, my lord. And after that, my lord, he submitted.
My lord, if my friend can answer one question, my lord, I will not make any further
Yes, I
submission.
will answer to any question. You
My
can-
lord.
I will ready to answer for your question.
Where is the judgment?
Page 82 starts, my lord. Para 13, your lordship is referring at page 85.
Yes. Read it.
My lord. In the backdrop of the above, let this court therefore analyze the submissions made by the learned counsel for the parties on the basis of the materials on record. From the materials on record and from a perusal of the writ petition, it is seen that the petition is completely silent about the fact that any part of the land purchased by the petitioner number 2 and 3 along with others wherein petitioner factory situated was acquired under the provision of the National Highway Act. It is only on the basis of the affidavit filed by respondent number 5. It is seen that the land measuring 0.072 hectares covered by so and so was acquired and an amount of rupees was duly paid. It is really unfortunate to note that this vital aspect of the matter was not disclosed, which is a material fact, more so when the petitioner has invoked the extraordinary and equitable jurisdiction under Article 226 of the Constitution. It is no longer res integra that when a person approaches the court, and more particularly the writ court, which exercise equitable and discretionary jurisdiction, the person is expected to approach the court by disclosing all the material facts. In the instant case, if the petitioner had disclosed the material fact that 0.072 hectares of the land had already been acquired and compensation was duly received by this court, would have been reluctant to issue the interim direction in the year 2018, which is 5 years from today. Under such circumstances, the opinion of the writ petition ought to be dismissed on the ground of suppression of material facts. But my lord, my writ petition was not dismissed. Now, my lord,
It was not dismissed, but
my
the
lord, let
opinion
let
was
me
formed
let
and this
let
court is this court.
My lord-
we were asking you the same question.
my lord, I am answering your lordships, my lord, if your lordship permit. My lord, when my lord will see, they have issued a notification. My lord, it is their document when they filed an affidavit. What is the area? What is the compound payment? I have received the payment. What they have taken, my lord, initially, my lord, whatever the front part of ours was there, they have acquired it because they had issued notice under 3E. My lord, they should have, my lord, acted. My lord, it's not that for me to measure, my lord, how much land they are acquiring. Then also, my lord, the circle officer came, the Lat Mandal came and demarcated my boundary with National Highway. Then only, my lord, when I have accepted the payment, I am starting my factory, my lord. Will not I take a risk, my lord, if it comes that if I encroach somebody else's land, my lord? It is much costlier for me, my lord. But what has happened? 2008, my lord, sale deed was executed. They had acquired the land, and then demarcation was done. My boundary wall has been constructed in 2008, my lord. Thereafter, in 2012, payment has been made. No documents, nothing has been given to me. And then notice was issued to my landowners. Now, my lord, they issue a 3 notice. My one question is, can they now also issue 3 notice? That is only for acquisition purpose. Lord, that purpose of 3 notice has gone, my lord, when they have taken part of my land. Therefore, 3 doesn't come. And therefore, 2002 Act comes into play, my lord. I am saying that let there be a fair determination on the part of the authority, my lord, because it is they who maintain the record, they have the record, and my lord, when the circle officer.
We'll list it next week. We'll list it next week. No issue. Except it next week.
Lordship, may kindly see the joint verification as per direction of the Honorable Court.
Where?
My lord,
My
will see
lord,
that.
the Honorable Court, by the order dated, my lord, page 57, my lord, order dated in this writ petition, order dated 2/8/2023, directed the subdivisional officer
Page 65 is the joint report, my lord.
to carry out a joint inspection. And accordingly, in compliance of the, that, my lord, the petitioner agreed with this,
no,
my lord, order, because the it did not, my lord.
Where, page 65?
Page 65, my lord.
Page 65 is the joint verification. Pursuant to the direction of this Honorable Court. As per the direction of ADC, in charge Rongia subdivision, I later mentioned above, a joint demarcation process was carried out along with NSAI officials and in presence of the petitioner for submission of the report in connection with WPC number 22. And the findings are mentioned below. During demarcation, it was found that petitioner has encroached 9 feet NSAI acquired land in the southern side and 20 feet NSAI acquired land in the northern side. And the boundary wall of the petitioner is situated over the NSAI acquired land.
Lord, if your lordship permit, Lord, this report is very interesting. Your lordship would see the signature. Lat Mandal, NHAI officer, circle officer. Lord, no petitioner signature. Second page, factory manager signature is there, Lord. The learned judge has recorded that though the signature of circle officer appears, he was not there. Therefore, the learned single judge has directed for fresh measurement. Now, your lordship would see that in this report also, Lord, even for the time being, your lordship would assume, where is it mentioned how many I have encroached? Lord, what is this? They say that 9 feet on this side and 10 feet on this side. What is the measurement?
Is argued on that point. He is required to file a civil suit.
No,
My lord,
absolutely not.
They have not said, they have not annexed any document in this writ petition, my lord, when that boundary wall has been constructed.
Lord, they have not disputed. I have filed a writ in my writ petition. There is a pleading, my lord.
Question of disputing does not arise, my lord, in the writ proceeding.
My lord will kindly see in my writ petition.
And in the writ petition, there is no whisper. My lord, only after the joint verification,
take
they
it up on
admitted that,
Wednesday.
he is the
Till
enforcer.
then, Lord,
This the matter on 6th.
till then some protection, otherwise this writ appeal becomes infructuous, Lord, because tomorrow is the measurement.
This is a
Let the measurement continue,
But
then you go and appear before, you go and join the measurement. But then after that, we'll see. But that's why I'm listing it on 6th. Tomorrow's measurement, after that, we'll see.
Let there be no demolition or only measurement, my lord. Then your lordship make it clear, my lord.
We make it clear that the measurement, the demarcation to be carried out on 30/11/2023 at 11 AM as directed by the learned single judge shall continue. Stop. However, no further steps be taken after the demarcation is done.
My lord.
Till 6th.
Till 6th,
My lord.
till the next meeting. The name of the learned standing council, Revenue Department. Be reflected in the cost list.
Can I make one prayer, my lord?
Yes.
That since the exercise is to be done tomorrow, let my learned friends inform their departments, because it would be difficult on my part to get a certified copy now and.
That's what they
No, already been informed. We will
They-
inform when
the
it's stable.
petitioner
Then
is
you
informed,
stay below regarding demarcation. Why do?
No, at least for demolition part, my lord, they should communicate whatever the order your lordship has passed. I'm not saying in part piecemeal basis, my lord. I'm deeply obliged, my lord.
Item 13 and 14 for orders.
Your Lordship, in PIL 2, we need some more time because we have already prepared our interlocutory application pertaining to the illegal appointments of the members in the Transgender Welfare Board. So in that regard, we need some more time to file our interlocutory application. But in the same, Your Lordship, but in the same PIL, so far as the direction which is required to be which is required from the other side to came up with the instructions, that why according to para number 6 the necessary action is not required to be taken from the court for making such derogatory and discriminatory remarks towards the transgender community at large.
That's fine. Why don't you file your IA?
Your Lordship, the IA is related to the Transgender Welfare Board. However, this PIL has come up with two aspects. One is the Transgender Welfare Board and another is the state level protection cell. Regarding the Welfare Board, we will file our interlocutory application. We need some more time. But so far as the transgender state level transgender protection cell is concerned, the other side is required to come up with some specific instruction which
You have any instructions not?
But in PIL 2, Lordship, I took time as regard the objection raised by the objection to the composition of this cell, as well as the guidelines issued by the National Human Rights Commission. That my lord, I am awaiting. I have not received, but I pray for some time to get that instruction. And as regard the incident, they have indicated what has happened in the Bongaigaon, my lord. I have received the report of those cases, my lord. And in fact, my lord, as regard the facts which have been brought by the petitioner for the manner in which the persons were searched, my lord, that we have taken up, my lord, that a guideline will be issued by the authorities very soon, my lord.
No. We are not wanting the guidelines. We want the necessary suspension of that officials.
No.
Your Lordship. Because no one has the right to check what is between the legs.
My lord, what has happened in Bongaigaon, I have the report, my lord. I'm placing it before Lordship.
You file it by way of an affidavit. So that
Yes, sir. Lordship, the detailed report of street search of apprehended transgender at GRP police station, Bongaigaon. These are the reports, my lord. Ultimately, the report reveals that from the medical examination report collected from the concerned doctor that the
Which are we reading from?
first page, my lord.
Oh.
The report is annexed with the first page. The first page is the letter to addressed to me, my lord. As per the second paragraph, my lord, as per the report, it is vivid from the medical examination report collected from the concerned doctor that the apprehended persons were normal male persons who disguised as an to dupe and exert the innocent passengers in the train. So those are the cases and the detailed reports are there.
Your Lordship, I have a strong objection to what
Let
the
me-
other
let
side
me-
is
let me-
talking about.
Let me finish.
No, you don't know the NALSA guidelines. How can you make such
Let
kind of
me-
submission? Your Lordship, see, Your Lordship, a transgender persons may be financially able or financially disabled. A transgender person may go for surgery, may not go for surgery. They might have not gone for a surgery because they are not financially stable. But how the officials got the right to took away those transgender persons to the concerned medical hospital and medically checked, and they provided a report, such kind of discriminatory report, which has not only violated the NALSA guidelines, but what the national and the World Human Rights Association talks about. Your Lordship, I just want to make some
I
submission.
can't submit beyond the
Trans
report.
persons
Whatever
are
is-
just
whatever I
a
have
minute.
received, I have
Just a
placed it
minute.
before Lordship.
You are not the
Lordship will definitely
expertise.
consider, my lord. My
The
lord,
other side is not the expertise.
I
Just
have
you
not in- I have
listen to
not
me what I'm
interfered.
saying.
I have not.
1 minute.
I have not interfered, my lord, during the petitioner's submission. my lord.
No. Whether you interfere or
I
don't
have-
interfere, I have got nothing to do.
before
The other side always makes such kind of nasty submission. I always avoid it, and this time also. Your Lordship,
Let him file this report by way of an affidavit. After that, you can make your reply or you can go through the same. Have you got a copy of this report?
no, not a copy has been provided to me, Your Lordship.
So
I'll
you want a copy provided to you, or do you want this to come by way of an
I-
affidavit?
In the form of affidavit, Your Lordship. Now, Your Lordship may just see once for a moment page 81 of my reply.
81 here. No, hold on.
Page?
Page 81 of my affidavit in reply.
Yes.
Here, Your Lordship, see, just a normal cisgender person who is supposed to be a reporter of Doordarshan. Now, what these pictures are now got viral. Your Lordship may just see it starting from page 81 to 83. Now, Your Lordship may just see page 83.
81, 83,
Page 81 is an affidavit in opposition filed by respondents 6, 7, and 8.
No, Your Lordship, my affidavit in reply.
Your affidavit in reply.
Yes. Page 83 of that affidavit in reply. The photographs, Your Lordship may.
You are on PIL number?
PIL 2, Your Lordship.
2. I don't have your affidavit. You have a copy of the affidavit? Oh, you have a copy of the affidavit? Page 81.
Page 80.
The photographs are there.
Page 83, the relevant photographs. If Your Lordship may just pursue for the time being.
Something wrong. There are no photographs. Page 83.
Page 83, Your
It
Lordship.
starts with gender identity. It's a continuation of paragraph 4 of the affidavit in opposition filed by the 6, 7, and 8.
I think the page numbering may be different if Your Lordship may just find.
You have filed affidavit in reply.
Affidavit in reply.
Let us see. This is affidavit in opposition. When did you file it?
Your Lordship, this affidavit was filed long back, before 20th of October.
You got? No. Affidavit in reply. Just check up if this affidavit in reply. Are you sure you're on PIL 2?
Yes,
Or
yes,
is it
yes,
PIL
your Lord.
6?
I think the documents has been misplaced, if I'm not wrong.
Just check up. Huh? Affidavit in reply. Affidavit in opposition, additional affidavit in opposition. There's no affidavit in reply. When did you file it? Do you remember the date?
Your Lordship, this was prior, before October, if I'm not wrong. Because your Lordship, on the last occasion, the CJ took up this affidavit in reply.
Oh, it was on record then?
Yes, yes, it was on record. Even the necessary direction was also been given to the other side to come up with an instruction.
You have a copy?
Yes, my lord, that affidavit in reply.
Oh.
Yeah. After the after the last order, I have been given a copy, my lord.
It is not here. Let's check if 1810 138. Let us see. Yeah. Yes, page 83.
Yes, page 83, your Lordship, that is a clear picture which has been getting viral and which has been circulated through the medium of Facebook, where many transgender persons have, your Lordship may find, was a stripe off inside the police station. Now, on the other side, what the other side was making a submission that they are completely male as per the medical report. Now, your Lordship may just see the definition of transgender under the Transgender Person Protection of Right Act. Now, your Lordship may just, for 2 minutes, your Lordship may just see the definition. It says, transgender persons means a person whose gender does not matches with the gender assigned to that person at birth and includes trans man or trans woman, whether or not such person has undergone sex reassignment surgery. Now, this is a very important part. Now, your Lordship, that is what I made in submission, that a trans person may be financially able or may not be disabled or may be disabled. But for that reason, how the police authorities got the right to apprehend them, to take them to the police station, and the striping of the transgender person in the police station is not at all admissible in the eye of law. And therefore, your lordship, generally the transgender persons are particularly vulnerable to human rights violations when their name and sex details in the official documents or in any other documents does not matches to their gender identity or expression. However, the vast majority of trans and gender diverse person in the world do not have access to the gender recognition by the state. And that scenario creates a legal vacuum and a climate that tacitly fosters stigma and prejudice against them. And therefore, your lordship may take this into account and make an immediate direction to the police authorities for immediate suspension of that officials.
Yeah, the issue is that we don't have your reply affidavit. We're just borrowing it from Mr. Nutt's copy.
But on the last occasion, your lordship, CJ, our previous CJ, Justice Sandeep Mehta, took up this affidavit.
That's what you are saying.
Yes.
Yeah, I don't know. Is it the? Not here. Well, what we'll do, we'll let the registry verify your affidavit in reply, get a copy on record. In the meantime, I'll ask Mr. Nutt to file an affidavit enclosing the report and
Yes.
also permit you to file your IA.
Okay, okay, fine.
Now
Okay.
we can keep it.
Yes.
Heard the petitioner in person. Stop. Mr. D. Nutt, Leonard Senior Governor Advocate, submits that he has received a report with regard to the incident that occurred in the Bongaigaon
Bongaigaon GRP.
GRPS. Stop. The Learned Additional Senior Governor Advocate is directed to file the said report by way of an affidavit. Within
Lordship, give us a week.
1 week? 1 week will do. In the meantime, petition in person is also permitted to file an IA in the present PIL. So in PIL 2 of 2020.
2 of 22.
22. Stop. When do you want?
After 5 days.
We list it after 1 week.
Okay.
Within a week, we'll file the affidavit. Today is Wednesday, my lord. Lordship, take up
8.
next Friday.
8.
8.
8 December.
8.
MS so Learned Council. MPS correspondent. 2, 3, 4. You can take your copy.
I'll take it.
My lord, I'm extremely sorry,
You-
it's regarding
you'll-
item number
you'll-
5.
Just a minute, my matter has not been finished yet. Your lordship, now PIL 6.
No, I'm listing it together on 8.
Okay, but your lordship, in PIL 6, I want a direction. If your lordship may just permit.
Yes. What is the direction in PL 6? Give me 6.
6 or instruction to take.
PL 6.
6 or instruction.
Your lordship, one of the transgender person, she is on board. Your lordship, on the last occasion, I have provided a copies where she applied for one of the police advertisement. But however, that police advertisement is only based on online portal, an online basis. However, she could not make her application submitted through that online portal because of there was no any necessary principles that were required to be involved by the police department. So in that regard, when on the last date she appeared before this court, your court has asked that on the next subsequent date, your lordship will pass in direction so that her application may be considered only to that extent.
Now Mr. Nutt is giving us the instructions that he has received. As per the instructions, it says the central / state government have not received any guidelines till date for providing separate reservation to transgender persons in educational institutions and public appointments.
But in that regard, if that is the instruction, then that is a clear violation to what the Transgender Act 2019 says, your lordship.
Let him file this by way of affidavit also, so that you can reply.
But your lordship, what will happen is, because the
Advisory
main
has been issued on
contention which
15th of September 2023. As per the affidavit filed by the affidavit and reply filed by the petitioner, I have received a copy, my lord. The advisory has been issued on 15th of September 2023, and pursuant to that, central or state government has not issued any guideline till date. Whenever the guideline comes, because the police department itself, a particular department cannot issue a guideline in respect of all the entire aspect has to be considered at the government level. That whenever the decision is taken, definitely police department is one of the departments. They will
in PIL number 6, you say heard.
now your lordship, if that is the case, then your lordship may just pursue the main PIL petition. Just for a moment. Only I will take 2 minutes, then I will wrap up. If your lordship may just take our main petition. Your lordship may just see the page number 72 of my petition.
PIL 6.
PIL 6, your lordship.
Yes.
Here, the other side is saying that there is no guidelines from the center on the state, and therefore they are unable to include transgender persons. Now, this was the advertisement which was challenged.
Yes. Our line has gone off. Is it a network or you tell her we're listing it on it along with you. There's no time.
My lord, it's regarding item number 5, my lord.
Yes.
My lord, that has been adjourned for a week, my lord. My lord, I have taken consent from the other side, and our presence may be recorded, my lord. I was on legs in court number 6, my lord.
What did I
It's
pass?
regarding appointment process of University Law College.
Okay. Okay, on request made by Mr. PG for
Your lordship, I just due to some technical difficulties, my
for the appellant list after 1 minute. Yes. Your line got.
Yes, your lordship, due to some technical difficulty, my video went off.
Anyway, I've passed over. We'll take it up on 8. If possible, try to be here physically. If not, there's no issue on the VC also. There's no issue. If possible, you can come physically.
On 8, your lordship?
8.
Okay, highly obliged.
Item 15.
My pleasure, Lordship. Lordship, they have filed an affidavit on 8th of November. Lordship, I am praying for a further time of 10 days to take my instructions, Lordship.
Lordship, I have filed my affidavit, Lordship. As per my nothing survived in the miscase, Lordship. Otherwise, they want some time, Lordship.
10 days.
Next week, candidate, Lordship.
Lordship, let it be next week.
Yeah, Mr.
A. Chakraborty, Lordship.
A. Chakraborty, Learned Counsel.
For the applicants, Lordship.
Who's the applicants?
Lordship, the Assam Judicial Service Association is the applicant hearing.
For the applicants, namely the Assam Judicial Service Association. On request made by, list matter after
1 week.
1 week, Lordship.
After 1
That may be fixed, my lord.
Give a date.
Oblige.
Item 16.
Lordship, in this PIL, in the last order in 22 September, my lord, 2 directions were given to implicate the party, that is Department of Revenue. My lord, we have filed an interlocutory application yesterday. However, the same could not be get listed yesterday, my lords.
The second was to file additional documents, my lords. With additional documents, my lords, we are ready. There are two issues. Basically, this case arises of a case wherein, my lords, massive destruction, which is adjacent to the Dihing Patkai National Park, was being done. So, with regards to eco-sensitive zone, to tag that it was between the eco-sensitive zone, we are ready with the documents, my lord. However, my lord, there is other.
What do you want?
This is the first case. A person comes. Normally, my lord, PILs are filed when trees are cut. No, this is a case, my lord, where he files a case PIL resisting my lord, plantation of trees. He was a allotment. He says he's an allotment holder, which is exploiting commercially by planting tree bushes in government land. We excavate everything, plant my lord's commercial trees and forest trees. He comes. On the last occasion when I had pointed out this portion, he seeks time and goes away.
My lord, I'm so sorry that he is interrupting between my submission.
This is unnecessary, my lord.
If you could be maintain the decency of this code, my lord, in my humble submission. My lord, first of all, this is within the eco-sensitive zone, my lord. I can take my lords to the eco-sensitive, all the guidelines of the eco-sensitive zone, my lords, wherein it will prove that whatever they've done is against the directions filed by the central government and the judgment in the apex court, my lord. That is my humble submission. And I can, if there is today, if not possible, my lord, I can take because it will be a brief, it will take some time, my lords. Secondly, my lord, they have also planted tree in the grazing land.
Whatever it is, what do you want today?
Today, my lord,
we're running short of time. That's why I'm asking you not to waste.
It can be listed on a next date, my lord, within 1 week's time, my lord. And secondly, my lord,
okay, Mr.
Amberman, my lord.
On request made by Mr. Amberman, then the counsel for petitioner list after 1 week.
My lord.
Yeah.
Much obliged.
And 17. Abusers should not teach us little about it.
Yeah.
The order has been complied with, and the demarcation has been done, and the land has been handed over to them. I have the paper.
Land hand over
MS Gyan, then the counsel for the petitioner submits that the respondent they've complied with the order. Or
yes, madam.
Have complied with the order passed by this court. Stop. According, Mr. D. Nath, then counsel appears for on behalf of the sole respondent. Condemned petition is accordingly closed. Don't say like that. Recording the submission made by the land.
Papers are here.
Condemned petition is closed.
Lordship, kindly keep the instruction on record.
Okay. The what is it?
Land has been demarcated.
Communication. Communication.
Yes. Land has been demarcated and it has been handed over to them.
The communications dated
today it has been given.
9/11/2023, isn't it?
No, the second page kindly see below. 28/11/23. This is by the circle officer to the ADC.
The demarcation dated 28/11/2023, written by the circle officer, Guwahati Revenue Circle. Same order. Okay, this is your side.
Look, okay, that. Demarcation has been done on 18/11/23.
Then he cancelled the whole order. Heard MSA Gyan, then I counsel for the petition. Mr. D. Nath, Leonard, counsel appearing on behalf of the sole respondents, submits that demarcation
has been conducted on 18/11/23.
Has been conducted on 18/11/2023, and the land has been handed over to the petitioner. Stop. Para. So he places to support the same. He places a communication dated 28/11/2023, written by the circle officer, Guwahati Revenue Circle. Stop. Para. MSA Gyan, and the counsel for the petitioner, also submits that the respondents have complied with the order passed by this court. So, accordingly, contempt petition is closed. The communication dated 28/11/2023 is placed on the court.
Item 18.
What is this?
This is for that expunging the remarks against the council.
And on that, I have filed one IA lordship for impleadment in in Debashish Sakya versus state case.
That is not allowed, no.
No, no, it can look like why and another I have filed for my own expansion. And then
Should we keep on expanding this matter or should we try to close it down at the earliest?
that is what is required, Lordship. But then thing is because the I was started with the application or clarification sought by the Inspector General of Prisons and the Superintendent Central Jail. So I have made them party because already the communication has gone to them. They already know that the things are said about us. So in my eye, I have made them party. And actually, TJ Mohanta, the senior advocate, he was representing them at that point of time. So, I leave it to Lordship.
Otherwise, expunging of remarks, Supreme Court has time and again said it is up to the court. And the court who actually hears the matter. Lordship will remember that Antule's case where certain expunging the remarks came before the Supreme Court. And the Supreme Court said the court where the remarks were passed, the court will exercise the power. And so as far as other authorities, I think will not be required.
But then, Lordship, I have also said that it is defamatory because I have in my petition, Lordship, I have mentioned the hours, the minute, the seconds, wherein I made the clarification. The first, I did say 11 years, 8 months, I suppose. Then, Lordship, and then I asked additional PP to clarify, and she said, I'll check the records. She checked the records, and then I counted on my finger. It's on the live streaming also, Lordship. I counted on my fingers that it is 5 years, and I had an interaction with Lordship regarding those 5 years. I said, I submitted the judgment. My judgments are one is of 5 years, one is of 7 years. And in my concluding also, that was at 2 hours, 30 minutes, 30 seconds approximately, Lordship. There also, my final prayer was, when I concluded, final prayer was that they have stayed for 5 years. So it was not my submission that they have, I corrected it, what I made. And that was made because and that is also in the live streaming that I said that because it was in the paper book, from the paper book that they were there.
Sister.
And Lordship, in the
1 minute.
yes.
Hmm?
For other cases, any clarification is required.
Okay. We'll fix a date for passing final order.
Lordship.
In
And
fact, even
Lordship,
I'll place few
the
judgments.
notices to them.
That is not required, Lordship, because
Not required, but just on the main issue is that remark.
And
Correct.
that remark is
If the thing goes, everybody's happy.
Yes, that is what.
it will be read
But
as
then
part
they
of the
should
original
know
order,
also
no?
that it is expunged. That will be my
Obviously, a copy of this will go.
yes, yes. Then it is fine. Then it is fine.
Hurt Miss Debashish Saikya in person. Also heard MS R.D. Majumdar. You're appearing in person, isn't it?
Yes, Lordship.
In person.
In both the in
Also,
her eye also, in my
As John,
two eye.
additional PP Assam. List the matter. When do you want? 1 week?
Lordship, the bench has to be
1 week?
constituted again. Because Lordship Nandi is
We'll take
sitting.
after 1 week, then. Oh, no, 1 week.
Tuesday.
Fifth is the holiday.
No, first.
5th of December or any day.
8th.
8th, Friday.
Then
Little early as a first item because I have to place 3 decisions on what will be the power under which Lordship will expunge and whether Lordship can look into the video, the footage. And the same court has to. So 3 decisions as placed. So Lordship will take it up.
you want an early date?
No, Lordship, on that
Early
day
date
only.
will also be better, Lordship. If on 5th.
If it's on 5th, Lordship.
5th is a Tuesday, Lordship.
Can it be
At 2.
Tuesday will be difficult. Let it be 6th.
6. At 2, Lordship.
2 p.m.
At 2, Lordship. Of Lord.
Deeply obliged,
Highly
Lordship.
obliged.
Item 19.
That is related to the content matter. I don't want to withdraw this matter.
Ms. A. Gyan, learned counsel for the applicant.
Applicant, yes, my lord.
Praise for withdrawal of this IA. Who appears for the other sides?
I'm from NDAS 345.
I am N. Bordoloy for respondent number 2.
MSN Botolo, Leonard, standing counsel.
Standing Council Revenue Department.
Revenue appears for respondent 2 and Mr.
NDAS Government Advocate 345.
Governor for 3, 4, and 5. IS economy dismissed on withdrawal.
Master.
Obliged, Your Lordship.
Item 20.
Web legal loss. My lord, this IA has been filed for limited prayer, my lord. Here are my lord 6 appellants. Appellant number 1, within bracket Roman 1, 2, 3, and 4. They are 4 brothers. And rest of the persons have executed power of attorney in favor of 1, Rina Mondal. Now, lordship may kindly see page 5 of the IA. Page 5 of the IA. Lordship would see after 6 Govinda Mondal, then the appellants number 2 to 6 are represented by Srimati Rina Mondal, wife of Amar Chand Mondal, the authorized legal attorney of the said appellants, these petitioners, so and so. So, this Rina Mondal is representing appellant number 2 to 6. But appellant number 1, now lordship kindly come to page 2, my lord, of the IA. Lordship, kindly see on the death of Hemanta Kumar Mondal, his sons and legal heirs, Amar Chand Mondal, Uttam Kumar Mondal, Gautam Kumar Mondal, and Nathuram Mondal. Now, my lord, this appellant number 3, Roman 3, Roman 2, Roman 3, Roman 4. They are executing power of attorney in favor of Amar Chand Mondal. And that power of attorney, lordship, we have annexed in this IA. That lordship may kindly see page 14. Page 14. So our limited prayer is this, my lord. Our prayer, lordship may kindly see page 12. And earlier occasion, my lord, the Rina Mondal was implemented, was made the representative by virtue of an order by the Honorable Learned Single at that time. So here our prayer, lordship would see kindly to admit this petition and substitute the present applicant, namely Sri Amar Chand Mondal, as the appellant number 1, being the authorized legally constituted attorney of appellant number 1, within bracket Roman 2, 1, 3, and 1, 4. Now, Amar Chand shall be the legal representative of appellant number 1, within bracket 2, 1, within bracket 3, 1, within bracket 4. So that is the only prayer, man. Now, in names, lordship may kindly say, Lord, names we have sent. That is, my lord, that may kindly see page 2. Names are there too. Uttam Kumar Mondal.
Your simple prayer is that the appellant number 1 is the power of attorney holder, and he'll represent at the appellants 1, 2 to 1, 4, isn't that?
Yes, yes, that is.
Why are we going so round?
Why not? Yes, that is exactly, that is my prayer.
Yes, not.
We have nothing to do. They are brothers. No?
Brothers. They are brothers.
So you'll have to file a amended course title again.
No, the registry will correct this.
No.
Nowadays the petitioner has to file.
You'll have to file your amended course title.
Yes.
Thank you, lordship details.
Not my desire. There's already a notification. Yes. I don't know that.
Yes, I know. Yes, I will do one. First order should be there, thereafter only we can file.
But Mr. M.U. Mahmood, learned counsel for the applicants. Also heard Mr. D. Nath, senior government advocate for the respondent.
Well, here I appear for respondent number 7, 8, 11,
One
9.
minute, 1 minute.
Lordship.
Union of India.
Union of India, CGSC will appear. Mr. Lordship, record the name of architect.
Mr. Arkadev Chowdhury, Learned DY, Deputy Solicitor General of India, appears for respondent number 1, National Highway, Mr. C. Barwa, Learned Standing Council, NHIDCL, NHAI,
6 to Dominic. 6 to.
appears for 2 and
2, 3.
2 and 3.
Lordship, I am for respondent number 4 and 6.
Respondent number 4 is the Secretary to the Government of India.
Oh, revenue.
Revenue department, but then there is Dispur Guwahati also.
What have you
It's a
done? What
typographical
have you
error,
done?
maybe, Your Lordship.
Why do you make all this type of mistakes?
No, no, because they are necessary parties because so many communications were made by.
Government of India ko
India likhte.
Oh, sorry.
Government of India is in Dispur.
I am extremely sorry, madam. Extremely sorry. This time.
You are appearing for
4 and 6, Your Lordship.
MS
And Bordoloi.
Portoloi, the Understanding Council Revenue Department appears for respondents 4 and 6. Chief Secretary
5, 7, 8.
and D. Nath, Leonard Senior Government Advocate for the respondents 5,
7, 8,
7, 8,
11 and 12.
11 and 12.
No, 9 also, sorry. 9 also.
9, 11 and 12.
Right.
Stop. Okay. The applicants,
Project director.
namely
Project director. Project director কি হয়? আমাকে কইতে দি।
Dear.
who's the applicant?
Applicant is my lord Amarchand Mandal.
Shri Amarchand Mandal. Who is the appellant number
1, 1.
1 within bracket Roman 1 in writ appeal number 286 of 2023. What did I say now? Don't say like that. The present application has been filed by the appellant number 1 within bracket 1, Roman 1 of in writ appeal number 286 of 2023. Praying for substituting his name as the appellant number 1.
Yes.
Replacing the names of the appellant numbers 1 within bracket Roman 2, comma 1 within bracket Roman 3 and 1 within bracket Roman 4 on the ground that they are all brothers, correct?
Brothers, yes.
And that the present applicant is the power of attorney holder to represent them.
Yes.
So, Learned Counsel for the respondents has no objections. Stop. Para, this court on perusal of the course shown in the present application is satisfied. And accordingly, prayer for implement is allowed. Stop. In the main writ appeal, in view of order passed today in IA number so and so, let Shri Amarchand Mandal be the main appellant, correct?
Yes. Appellant number 1.
Be the main appellant within bracket appellant number 1. And the names of the appellant number 2 or 1 within bracket 2, 1 within bracket 3, and 1 within bracket 4 be deleted, correct?
Yes.
Be deleted. Stop. The appellant is directed to file an amended cost ID.
Hello.
List after
2 weeks.
2 weeks. Finish.